I've been practicing in the area of education law and children's rights for 20 years. I'm still frustrated to see cases like this one where a child has been denied access to education because of special needs, because the school says they cannot help the child and the child should just stay home. This is entirely unacceptable and it's against Ontario law, and that's why I'm doing this special edition of my podcast to explain why. My name is John Schuman. I've been practicing education law in Toronto, Ontario for 20 years. You can reach me at the contact information at the bottom of the screen on this video. As I said, I'm doing this video to go over why it is that it is illegal for a principal to tell a child that they cannot attend a publicly funded school because they have special needs that the school cannot accommodate. Getting an education is crucial to children. They must attend school, not just for the academic part, but be socialized and learn how to interact with other people. They just don't function if they don't get an education. Parents of special needs children know this, and they know that it's critical that their children go to school. So what do when a principal tells them, just don't bring your son to school anymore? They tell them, sorry, that's just not allowed. It is true that under the Education Act of Ontario, that principals do have a duty and the legal authority to keep people out of schools to protect the physical and emotional well-being of the people there. That includes both students and faculty and staff at the school. However, as of the time I'm recording this podcast in May 2019, there is an important exception to that. To find that exception, you look at Ontario Regulation 474/00. This is the regulation that governs how principals can use their power to keep people out of school. And you look at specifically section 3 sub 3 of that regulation. That regulation, or that part of that regulation, says specifically that when it comes to the sections that allow a principal to keep people out of school, it says specifically that those do not apply to a pupil enrolled in the school or to a pupil attending a program for suspended or expelled pupils that is located on the school premises. What does that mean? That means that if your child is enrolled in a publicly funded school, it's either their home school or the school board has assigned them to that school, they cannot be excluded from that school. They cannot be told just not to come to school. They have a right to be there, and the principal does not have the power to kick them out. There are 4 ways that a principal can keep a student out of school in Ontario. The first 2 of those are suspension and expulsion. Those are drastic penalties for the most severe behavior because it denies a child a right to an education. Both suspension and expulsion have very specific criteria that a principal must follow in order to suspend or expel a student, and only specific criteria when those particular punishments are applicable. In addition, both suspension and expulsion have appeal procedures. In the case of expulsion, that involves not only a hearing before the board before a student can be expelled, but also an appeal to an independent body, the Child and Family Services Review Board. Suspension and expulsion, most notably, should not be used to expel a student or to deny a student education when that student is not having their needs met at school. That is specifically a thing that a principal is required to consider before they impose those punishments, and it's one that the Child and Family Services Review Board takes very seriously when considering whether a child should remain expelled. You cannot kick a kid out of school for having special needs, and you cannot kick a kid out of school if the school is not dealing with those special needs appropriately. Another way that a principal can move a child to another school is through the IPRC process. Many parents of special needs children know what this is. It is the Identification, Placement, and Review Committee process. That is to identify a student as having exceptional needs, either by way of having special learning needs, having physical disabilities, or perhaps being gifted. When a student is identified as exceptional, the school must put accommodations in place for them. Sometimes schools cannot provide appropriate accommodations within the same school the child usually attends. In that case, the student may have to be moved to another school to a special classroom. That is done through the IPRC process. Parents participate in that process, and they have a right to appeal it if they don't agree. So it's not an easy process to move a child out of the school just on a whim. A principal has to do it appropriately and in consideration of what the child's needs actually are. Finally, a child can be transferred to another school. In cases where the student or the parents don't agree, that's an involuntary transfer, and is often called a fresh start. The fresh start procedure exists to do exactly as the name suggests, to give the child a fresh start at a new school, to start over without whatever happened at the last school dragging down their education going forward. However, fresh starts are usually only imposed when there are specific conditions in place that prevent the child from being able to attend their previous school. That usually involves some sort of criminal court or family court order that requires the child to not be at that school. But it can involve other very specific and difficult criteria that require a child to be at another school. If your child is being fresh started and you don't necessarily agree, again, it's time to speak to a lawyer. Aside from those 4 ways, there's no way a principal can remove a child from a school. They can't just tell them to stay home. The law just doesn't allow it. So if your child has been kicked out of school without one of those 4 criteria, if they have not been suspended, if they have not been expelled, if they have not been IPRC'd to another school, or if they have not been fresh started, then you really do need to speak to a lawyer. And if your child's needs are not being properly accommodated, then you should take your case to the Human Rights Tribunal of Ontario or to court. Speak to a lawyer about doing that. These cases are common and there are remedies available. Your child needs an education and you need to do what you have to do to make sure they get it. It's important for their lifelong progress. My name's John Schuman. I'm an education law lawyer practicing in Toronto. You can reach me at the contact information that's been at the bottom of the page. Thanks for participating in my podcast. We will do this again soon.